My name is Soody Tronson. I'm the founder of STLG, which is an intellectual property boutique law firm here in Silicon Valley. And I have the pleasure of today speaking with my friend, Eric Schulman, who's the head of intellectual property at Uber, and lots of experience coming from Google and lots of other places. So why don't you tell us a little bit about your background so we can get into the topic of today.
Sure, and thanks, Soody, for inviting me, and thanks for coming. And I hope we make this, it's a small group, so I hope this is basically a conversation. What's that? Better, yeah.
You don't even need this.
Yeah, exactly, we'll get rid of this. So by way of background, I've been at Uber for a little over 8 months now as the head of their intellectual property function. Prior to that, I was 9 years as a legal director at Google, focused on patent issues, and happy to talk about all the public stuff that's happened there. Pretty interesting times, the smartphone wars and that sort of thing. But I think the thing that might, we're going to jump into some of the talks about what's often referred to as the patent troll problem. And but happy to talk about anything that's patent related that might be of interest to you all. I'm curious to know sort of the composition of the folks here. This is mostly folks who are sort of involved in innovative companies and thinking about a connection between Israel and the Valley. That's basically the situation. So I'm hopeful that this topic will be pretty interesting. Unfortunately, the so-called patent troll problem has exploded and is targeting not just large companies like Uber and Google, but more than 50% of the defendants in these suits are small companies with less than 10 million in revenue, and we'll get into this. But I'm hopeful that this will be relevant to you, and also what I'm going to talk about will hopefully be relevant to you in the sense of you may also be thinking about how do I commercialize my IP with regard to large companies and that sort of thing. So we can talk about that as well.
So as Eric, as you mentioned, we talk about commercialization, market entry, and coming into new markets, including US, which is one of the biggest and the most important ones. But a lot of times companies don't necessarily think about their technology, they do the market studies, but they don't necessarily think of the barriers to entry once they are successful. And once you're successful is when problems start happening. If you're not, nobody cares. So one of the biggest things that we see as a challenge for younger companies is the whole intellectual property. Not just having your own to assert your own property against infringers, but also how do you defend your products, your market, your business as you're entering, let's say, just the US market alone, from people who are not even valid in terms of their position in the assertion of the intellectual property. So what is LOT and how is it supposed to handle and help the young companies coming here?
Sure. And maybe I'll just lay out the problem first, give you some context. And please just jump out with questions. Don't hesitate to interrupt me. But I'm pretty passionate about this, so I'll keep going until you do. So what is the problem? Back in I think about 2006, patent assertion entity suits or patent troll suits represented about 19% of all patent litigation in the United States. Today, it's almost 70% of all patent litigation is patent assertion entity. I see a wow was just mouthed. Turns out in the high-tech space, it's 84% of all patent litigation is this troll litigation, right? And how much does it cost to defend one of these suits? How distracting is it for you, especially if you're a small company? Well, it costs $6 million just in legal fees through trial, if there's anything at stake, right? And that's just the legal costs. It's not the disruption to you or impacts on your product line, all that sort of thing. How much does it cost to buy one of these patents? It's only about $110,000 on the open market to buy one of these patents. So you have these assets that are fairly inexpensive to buy, but cause a lot of damage, right? And as I was saying before, small companies get hit all the time with these. The argument that I'm a small company, I don't have a ton of revenue, I'm not going to be a target. The trolls know that they can bother you with these nuisance suits and just get nuisance value out of it. Yeah. Yeah, it's a great question.
How do they identify the target?
Yeah, so I mean, first of all, how do you start a troll business? In case your first venture doesn't go well, yeah. And by the way, I mean, patent assertion entities I think are valid. Like there are individual inventors and R&D labs and universities that need help sometimes to commercialize their patents. The thing I'm particularly concerned about is this process where operating companies sell patents, and that's the source of many of these patents, is operating companies build up these huge treasure troves of patents. Like Google as an example, spent billions of dollars obtaining patents to defend itself. Then the carrying costs for these huge portfolios are huge, and they have to sell off some of their assets to defray those costs. Those assets end up in these patent assertion entities' hands. So it turns out that 80% of the patents that are being asserted by these trolls are coming from operating companies. So it's either these big companies that are selling them off, or oftentimes small companies will fail, and then their patents end up in the hands of these PAs. So, and to start one of these troll companies, it's quite easy. You just basically buy a patent, and then either, and oftentimes it's lawyers who are involved, but sometimes, or you can go get a contingency fee law firm to represent you.
You just need an LLC in Texas.
Right.
Usually,
exactly.
to do that.
And so, and another interesting stat that I'll start just to lay out the problem before diving into what the solution is at scale. Another interesting statistic is that 40% of the money that's paid to the patent trolls goes to buying additional assets, right? So you solve your problem today, and you're creating 2, 3, 4 problems down the road. So what's to be done about this? Well, you can go to the Supreme Court and other courts and try and change the law. You can lobby the legislature to change the law. And all these things are being done, but you need many tools in your tool chest to solve this problem, because even though many of these techniques are being pursued, the problem is continuing to grow. So how do we tackle this at scale? Well, one idea we had is, what if there were an open program, any company can join on, and everyone who joins on agrees that if they transfer patents outside the group, they'll license people in the group. So it's sort of like a arms control treaty, or like everyone get in the castle, and we'll keep all the patent trolls on the outside, right? So that's the basic idea of the license on transfer agreement. There are carve-outs for change of control and legitimate M&A activity, but that's the basic idea. Yeah.
Is that retroactive, what you just described?
No. So
it wasn't in the group
right.
a year ago, and you issued a patent there, and then I joined you, and I'm a new company. Is that under this protection?
Right. It applies to your whole portfolio. But it, obviously, if you've transferred patents before you sign on to this agreement, it doesn't cover those patents that have already been transferred out. So that's the basic idea. We launched last July. We launched with 6 companies. We've now grown to 42 companies. We have more than 325,000 patents in the program. Billions and billions of dollars of patents are already in this program, and it includes companies like Google and Canon and Uber and Dropbox and Ford and Mazda and JP Morgan Chase, and then as well as many smaller companies. Yeah.
Google and Facebook would not do that together. I mean, they would not join the group because maybe...
It's not for Google against, let's say, Uber, or Google against Facebook. Is for those outside. So those who are inside the group, right? You can still battle all you want.
That's exactly right. This agreement does not impact your normal business uses of your patents in any way. You can still cross-license. You can assert for feature differentiation. You can out-license. You can do all of that. This is really narrowly tailored at pure patent sales for offensive purposes. So really narrowly directed at the troll problem.
So how does, for example, if we have a young company that is thinking of the US market, and they're going to be very sensitive and direct victim, probably future victim of one of these groups, and they want to join this bigger consortium.
Yeah.
How do they do that? Is it cost prohibitive?
Yeah.
What can they do?
Yeah,
what
great question. So if you guys are interested in this, you can just go to lotnet.com, LOTNET.com. There's a website that describes it all, and you can you just pull the agreement there and take a look at it. And then if you're interested, and there are decks that describe it. So if you don't want to even read the legalese, there are also lawyers who've already vetted it. So you can talk to very good lawyers who've already looked at this. So it's inexpensive from that standpoint if you want to do your diligence. And then the fee is $1,500 a year, which is, the ability to get royalty-free inbound licenses to more than 325,000 patents and growing for $1,500 a year is unheard of, and we're trying to get it to be free. I'm working on getting this endowed. We've raised a bunch of money, so it's to do the recruiting and marketing and that sort of thing. But
so, what if you have a company And after a few years, they decide, well, this is not for me. I want to actually sell the company, including the IP that is one of my biggest assets. How does that affect them so that the value of their company is not reduced for sales purposes?
Yeah, great question. So, as I was saying before, change of control is carved out of this, so an M&A activity. So it doesn't impact that at all. The only thing it impacts is pure patent sales, and there are a set of value-preserving provisions. The main thing it's directed at is if you're planning on failing and selling to a troll, most companies aren't optimizing for failure, right? And if you can avoid one patent litigation or avoid one pre-litigation patent assertion that's of any significance, this is you'll more than have made the benefit of some theoretical diminution in the value should you decide to sell to a troll down the road. IBM sells their patents all the time for good value. Those are some of the most heavily encumbered assets out there. You can still sell your assets. It's just a small change in how that'll happen.
So does this at all protect against the other members? And for example, again, a young company coming in, okay, so they're going to be protected against the trolls who are just going after a small company just so that they can get some settlement value. What do they need to do so that they also have done their due diligence with respect to larger companies? How do larger companies, operating companies, may treat the same young company compared to a troll?
Yeah, so as I was saying, you still preserved all the real uses of your patent portfolio. So if you want to, let's say you're worried about a big company like Google or Canon or something like that, your patents are still just as potent against them as they ever were. It's just you don't have to worry about trolls coming after you.
But what about the other way around? If you were to compare trolls to some big companies like Google and Facebook who have a lot of patents, how do their practices on the offensive differs from a troll?
Yeah, so the nice thing about this, the problem with trolls is that if they assert against you, you have no way to assert back against them. You have no defense, right? They have no products that you can assert back against. Not only that, there's asymmetric legal costs because they can ask for discovery, especially if they sue you in the Eastern District of Texas, where there's often very broad discovery requirements. So you have to produce anything that's reasonably related to the litigation, and so it ends up costing sometimes millions of dollars just to do the discovery piece. Whereas you ask the same kind of discovery requests of the troll, and they produce a box of stuff because that's all they are. It's just that box. And so there's this tremendous asymmetry, and they leverage that to get larger nuisance settlements and that sort of thing.
So if we had some bona fide inventors who do have IP, but they do find another company, large or small, who's infringing their intellectual property, what are the options for them?
Yeah, so there are a variety of options, and as I was saying before, I think you can talk to there's always law firms that will work on contingency fee basis if you don't have the wherewithal yourself to assert your patent rights. But in my experience, and I can say this as a person who's both worked at a firm and worked in-house for more than a decade now, the firms that respect large companies, operating companies, respect the intellectual property of others. If no self-respecting in-house counsel wants to willfully infringe the IP of another company. So if you're a company and you're bringing something to bear, some intellectual property to bear, and companies will engage with you and deal with that. I think it's best if you can approach the company in a sort of respectful way and through people who, through your network in a way that it's people they know and trust, as opposed to sort of a holdup. But, if you're not getting that kind of attention, then sometimes you do need to send a letter from a lawyer, in a well-respected law firm. But in my experience, certainly when I receive a letter that's based on substance, I certainly respond to those.
I think it's also the issue of reputation. Larger companies typically also don't want to be associated with being, the company that is stomping on everybody else and is stepping over younger companies. So
yeah, the problem I would say is just this device alone is how many patents do you think relate to this device? Yeah, the estimate is 250,000 patents on this one device, right? This is not like the bio space or, the drug space where there's typically one or maybe a few patents that relate to a drug, or even the medical device space where there might be a portfolio, but it's a reasonable portfolio. 250,000. How are you possibly supposed to diligence all those patents? It's very challenging. So as long as you keep that in mind when you're, when you're talking to big companies.
So that actually brings a question. So the companies that you just mentioned as members of this organization, they don't include, or do they have to, or do you exclude medical and bio, or is it restricted to a certain kind of technology?
No, it's completely open, and interestingly, it's the membership is diverse geographically, technologically. So we've got Canon in Japan, SAP in Germany. It spans, automotive. We've got Ford and Mazda. It's finance with JP Morgan Chase, energy with Solar City. It's a wide variety. We've got hardware, we've got software. So it's completely agnostic. We would welcome medical device, and we've had some interest. We would welcome bio and pharma, but this problem is particularly pronounced in the high-tech space where the troll problem is particularly bad there.
So,
one other point I wanted to make is another great thing about this approach is what it's doing is it's really narrowly tailored at solving this problem of what economists refer to as social loss. So there's tremendous transaction costs here. How much money do you think the sellers of the patents get as a percentage of how much money is extracted from the community? Any guesses? Yeah, the question is, what percent is a percentage of the total amount of money that gets extracted from the community from these troll suits? How much of that money is going to the sellers of the patents? 5 to 10%. So it's effectively, and the way you can tell that is, there are a variety of ways to tell that. I have access to a lot of information about this, but even the average person can go look at publicly traded patent assertion entities and look at their finances, and you can see this. But it's effectively like, I'm selling you my patent right now for 5 cents, and you turn around immediately and say you have to buy it back for $1. That's what the tech community is doing to itself, right? It's what economists refer to as social loss, and most of that money is going to the lawyers and the brokers. No, the model is simply to have licenses become effective when the assets get transferred out of the group.
It's more like a shield. If you look at it from a sword and shield kind of perspective, it's a shield. It says if we are friends, if you're part of the same team, if you decide to go outside, you can, if it's legitimate and you're selling it to an operating company as part, you're selling the whole company. But if you're just giving it to some robbers, over there,
right.
I'm going to be protected. I have that shield. Is that?
Yeah, that's exactly right. So let's say Soody and I are in the
When you speak of shields, and there are a lot of talks of patents without lawyers that are talking only about canceling all the patents in the world and throwing all of them out and making. There is a talk about it in the tech community at least, and I don't know if it's a valid one.
I can't imagine.
There are at least treaties in Israel where you can sell to trolls. Like you need to sell only to an operating company. You can't sell outside, or if you agree to someone who doesn't have an operating company.
Well,
yeah, and I should say you can still sell to trolls under this program. It doesn't prohibit it. So let's say Soody and I are in the license on transfer agreement, and here's Mr. Troll. I can sell to Mr. Troll and get good value. It's just when I sell to that troll, Soody gets a license. So she doesn't have to be worried about getting hit with that. But let's say this gentleman over here and we're hard competitors, and he's selling patents to a troll to attack me because he knows it's going to raise my costs, right? I can sell to that troll as well and play in the same games with him, but Soody doesn't have to worry about it. Does that make sense?
Eric, has this changed how you've staffed up your legal team within Uber, and how you've used outside counsel or anything, given this possible solution that still is at its growing stage, but growing tremendously?
Yeah, no, it hasn't changed how I've staffed because this is a great advantage already, but the real bang is going to be down the road. I mean, so there's another organization called the Open Invention Network. I don't know if anyone's heard of that, but it was an organization that was started in 2005 by IBM and a set of companies to help defend Linux from patent attacks, mostly from an unnamed company, large company whose offices we're in right now, part of their framework is they had an open community-based patent cross license just around the field of Linux. And they started off kind of slow, but they've grown to 1,800 licensees right now. So that's the kind of scale. We're trying to get to that scale or even larger. And when we get to that kind of scale, then maybe it'll start to have that kind of impact. But that's a long way down the road, right? We need to really scale to get to that state. So the problem, unfortunately, the problem is continuing to grow. With recent changes in the law and that sort of thing, people thought the problem might be coming down from its historic levels, but it's popping right back up to historic levels again. So it's a real problem. It's a huge, it's a tens of billions of money, direct costs are being spent on this every year. So.
It's not so much the patent itself, it's how it's being used, and that's what LOT, I think. And
that's right, yeah, and to this point about how does this play with the patent system, this is a system that respects the patent system and in fact wants to see the patent system get better, right? Because as I was saying before, it's taking away sort of that social loss piece and directing all those revenues to the real area that it needs to be in, which is helping innovators like yourselves be able to, let's say I'm an individual inventor and I come up with a patent and I don't have the wherewithal to make sure I commercialize my IP. That's not this problem that we're talking about, right? That the resources should be going to those kinds of situations or R&D labs or universities. That's where the money and resources should be going, not to this social loss scenario where operating companies are selling off and then just having the assets sorted right back against them, if that makes sense.
Thank you, Eric.
Thank you for everybody. I love it.